May I please, Your Lordship?
Yes, please.
Lordship, I beg to mention item number 13. Lordship, on 23/7/2024, I was granted 3 weeks time to file reply affidavit to the affidavit in opposition.
Item
13, 1-3.
1-3.
My lord, on 23/7/24, I was granted 3 weeks to file reply affidavit to the affidavit in opposition filed by respondents 7, 8, and 9. However, my lord, in view of the Independence Day, my clients could not avail leave to come to Kohima for instruction. I'm bringing another 3 weeks time. I have taken concern from the other sides.
Okay, Mr.
Will it be on 10th of September, Lordship?
Mr. Takamasa, Srinagar, advocate, appearing on behalf of
The petitioners.
petitioner, raised for further 3 weeks time to file reply affidavit to the affidavit in opposition filed by the respondents.
7, 8, and 9.
For 7, 8, and okay, 9. The prayer is allowed. List is matter after 3 weeks.
Let it be on 10th of September, Lordship.
10th of September.
Lordship,
okay,
yes.
Is prayed for.
Yes.
List is on 10th September.
Much obliged, Lordship.
Okay.
With your lordship's permission, I mention one matter, my lord. I had filed a quashing petition under 482 on Saturday, my lord. If it may be listed today, my lord, the reason is this, my lord. A sitting cabinet minister in the government of Manipur has been issued a summon, and he has been directed to appear on 25 before the magistrate in Dimapur. My lord, I'm seeking an urgent stay.
For listing,
Please, my lord,
for listing, probably the mention is to be made to the senior.
before court one.
Yes.
Lordship, this matter will come up before your lordship only.
This is first time only.
Yeah, fresh matter, criminal petition
First
for
we
it.
have to mention, I think, for probably in court one.
Court one.
No, isn't it? Oh, yeah, can be mentioned.
Lot of other matters.
Okay, other measures are there. Tomorrow,
Tomorrow I have no problem. I'll stay back. I've come from Delhi all the way.
okay.
Please.
Yeah, please, the lordship. Lordship, I beg to mention hearing item number 27, lordship. On behalf of additional AGB Sokwe, lordship. If 27, if this matter can come up on 5th of December.
8th.
5th
of
September.
September.
No problem.
No problem, Lordship. Consensus date.
On the joint prayer made by both the Land Council for the parties, list is matter on 8th.
Your lordship, if 23rd is possible for the other
No,
parties.
party,
Which
no,
one?
23rd. You decide first.
Your lordship, okay, 5th September.
Is it? Okay, 5th September.
And Lordship, similar prayer for 26th, item 6, on behalf of Enkel Lukum. If the matter can come up on 23rd of September.
This is 23rd. You have
Yes. Enkel
applicant.
Lukum
Your lordship, I'm appearing for
26.
respondent number 3.
For the appellant, Lordship.
So you have no problem.
No, your lordship.
Okay. On the prayer made by Mr. Procedural and counsel for the petition appellant, to which Miss
And Solo,
appearing on behalf of respondent number
3.
3. And Mr. Zimomi is also appearing. Okay. There's no objection. List this matter on 23rd September. Okay.
Much obliged.
Lordship, I beg to mention item number 8. Item number 8, Lordship. On behalf of Enkel Lukum, for the respondent, Lordship. Item number 8.
Hmm.
Lordship, if the matter can come up to 2 weeks, Lordship.
I have informed the
Yes, Lordship. The petition is here.
May I please, Lordship?
Mm.
Lordship, here the respondent, they have filed in opposition to the order that passed by the Honorable Lower Court, Lordship. So, Lordship, instead of filing the affidavit, they should have challenged the very order, Lordship. However, they filed affidavit in opposition, Lordship. And the lower court has already decided the matter regarding the substitution of the appellant, Lordship, here. However, instead of challenging that very order, they are filed the opposition, Lordship. So if they, this matter, instead of filing opposition, Lordship, they should challenge the order, Lordship.
so is their choice. So
Lordship, I'm not this matter, but since I've been instructed
Hmm?
by Mr. Enkel Lukum,
So you have- in the IA, who is for the applicant in IA?
Lordship, there is 2 IA and one 28 of 23, that is the I have filed, Lordship, for the substitution, Lordship.
Substitution.
Lordship. And again, there is another IA, Lordship, 48, that is been filed by the adopted son of the late appellant, Lordship.
48.
Yes, Lordship. So this matter has been already decided, Lordship, in fact, by the lower court, Lordship. This honorable court directed, Lordship, the district judge, Lordship, to decide the matter regarding the substitution of the appellant, Lordship.
Substitution. And your prayer
Lordship.
is, Mr. Pasek,
Lordship,
what is your prayer today?
Lordship, I've been instructed by Mr. Enkel Lukum, 2 weeks, Lordship.
2 weeks.
So, Lordship, there is no ground for refixing the matter. In fact, it's already decided, so the substitution application should be heard, Lordship. Since they are not challenging the order passed by the district court.
Is there any stay?
No, Lordship.
No. So then,
Since the council is not here, Lordship, it will make me come up to 2 weeks, Lordship.
okay, so council is not there.
So, I need to consider it, Lordship.
After
Up to 2 weeks, Lordship.
2 weeks. Mr. Pasek Patel, land advocate appearing on behalf of Mr.
Enkel Lukum.
And land counsel for the respondent.
So responded, Lordship.
Okay, respondent.
Please,
Praise for listing this matter after 2 weeks. Mr. Mika H.I. Miss Mika H.I. Land counsel for the applicant is also present. Has prayed from. Has prayed for her, comma, list this matter after 2 weeks. Okay. Let them file appropriate application thereafter. After appearing. Okay.
Lordship, item number 3, Lordship. My senior has some difficulties today, Lordship. Item number 3
Okay.
is for the counsel for the petitioner, Lordship. So, Lordship, if the matter come up to 3 weeks, Lordship.
Mr. Sega Forte. Land counsel for
Petitioner, Lordship.
petitioner submits that his senior, Mr. P.B. Paul, has some difficulties today and prays for listing this matter after 3 weeks. Okay, Mr.
I'm sorry, Your Lordship, for respondent number 4, Your Lordship.
Nana counsel for the respondent number 4. He is present and has no.
Number 3, Your Lordship.
Okay. Yes, no, okay. Accordingly, the prayer is allowed. List this matter after 3 weeks.
Lordship is an interim, Lordship. Finally, the interim continue, Lordship.
Stop, huh? The interim order passed earlier shall continue till the next date. Okay.
Lordship, I also like to mention items 16 and 17 on behalf of Mr. Elaville, counsel for petitioner. 16 and 17, Lordship. Lordship, if the matter come up next week, Lordship, after a
For
week,
the petitioner.
petitioner, Lordship. Mr. Elaville's out.
Okay. Mr. Fortuna, for the Lana Council. Appearing on behalf of Mr. You are appearing on behalf of
Mr. Elivil Zhao, counsel for the petitioner.
Level zero, okay. Lana Council for the petitioner, praise for listing this matter after 3 weeks.
Lordship.
The prayer is
No,
allowed
1 week, Lord, 1 week.
1 week.
Lordship.
1 week, okay. Listing this matter after a week. The prayer is allowed. List this matter after a week. Okay.
Lordship.
May it please my lord,
Yes.
I beg to mention item 36 hearing. I've received instruction just few days ago. Therefore, I may be granted 3 more weeks time to file my additional affidavit.
Okay. You are for petitioner.
Yes, Your
Okay,
Lordship.
Miss.
On behalf of my senior Nito Koza.
Okay. Appearing on behalf of Nito Koza, is present, Mr. And Mr. Land additional. Submits that he has just received instruction and praise for 3 weeks time to file affidavit. Okay. The prayer is allowed. List this matter out for 3 weeks.
Much.
Okay.
May it please your lordship, I beg to mention hearing item number 38.
Yes,
My senior has some personal difficulties, so kindly list the matter after 1 week.
after 1 week.
Lordship.
Okay. Miss,
Lordship, in that case, after 2 weeks, Lordship.
after 2 weeks. Okay, Miss,
Mention
counsel for the petitioner, praise for adjournment of the case for today. And listing this matter after 2 weeks. Mr. Pacifico Forte. Land counsel for the respondent number, you are appearing on private respondent, okay, Mr. Angami. For the state respondent and Mr. Pacifico Forte, land counsel for the private respondent. There's no objection. According to the prayer is allowed, list this matter after 2 weeks. Okay.
May I please, Lordship, I'd like to mention hearing item number 39.
39,
Let the matter come up after 2 weeks
for the petitioner,
petition.
okay,
I'm for the private respondent.
private respondent, okay. No objection,
It's no objection.
Mr.
Nang sangaya.
Land counsel for the petitioner. Praise for. Praise for listing this matter after
2 weeks.
2 weeks. Mr. Iralo, Mr. Angami and Mr. Angami. Appears on behalf of the state respondent and Mr. Iralo. For the respondent, a private respondent. Stop, is prayed for, come up, list this matter after 2 weeks.
Lordship, interim order may we continue. Interim order.
Interim, yeah. Okay, the interim order passed earlier said continue to the next date. Okay.
May I please, my lord.
Yes,
Item number 4, Lordship.
yes,
Can you pass over the matter for the day, Lordship, and enable me to file affidavit, Lordship, of compliance?
Mr.
Lordship, no.
Okay, Mr. What is the counsel for the petitioner is present? Mr. Angami. Praise for adjournment of the matter. For,
Thursday, day after tomorrow, Lordship.
okay, for the day. In order to enable him to file
Affidavit.
affidavit. So the prayer is allowed. List this matter.
Thursday will do, Lordship.
22, Lordship.
22. 22, okay.
22A.
Bless you, Lordship.
22. Yes,
Lordship, then on behalf of MSA, IME for state, Lordship, item number 29, 30, and 31, Lordship.
okay.
Lordship, can you lease the matter after 1 week, Lordship? She has some difficulty with it.
Or have you informed the petitioner?
I could not locate any of them.
Hmm?
I could not locate any of the other council.
So. Can we wait for some time?
Yes, yes.
Just inform them if it's possible.
May I please, Your Lordship. Lordship, I beg to mention item number 11, Your Lordship. Item number 11, Your Lordship. Lordship, the leading counsel, Peter Suren, has a personal difficulties today, Your Lordship. So I pray that this matter will come up after 1 week, Your Lordship.
Mr. Middleton, Land Council. Land Council, some is that the leading council is out of station.
After 1 week, Your Lordship. After 1 week.
Okay. Is out of station. Would not appear, is not in the court today, and pray for listing this matter after a week.
A week, Your Lordship.
After- okay. The prayer is allowed, list this matter after a week.
There's an interim.
Mika, you are appearing on behalf. Okay.
Respondent Lordship.
Mika, Land Council for the respondent number
Also respondent Lordship.
is present. Okay. Then the prayer is allowed, list this matter after a week, huh?
Lordship, there's an interim, Lordship. There's an interim,
Interim
Lordship.
is also there.
Yes.
The interim order passed earlier shall continue till the next day.
Much obliged, Your Lordship.
Okay. Next.
Please, Your Lordship.
Yes.
Lordship, I beg to mention item number 5 on the admissions list.
Hmm.
Lordship, if this matter can come up after 3 weeks, we are for respondent number 1.
You are for respondent number 1.
Yes, Lordship.
Have you informed?
Yes,
Yeah.
Lordship.
Okay, Mr. Plus. Mr. Madhavira, Land Council for the petitioner, applicant is present. Mr.
No answer on behalf of respondent number 1.
Hearing on behalf of respondent number 1, praise for listing this matter after
3 weeks, Lordship.
3 weeks.
Lordship, I also
Prayer not objected. List this matter after 3 weeks.
3 weeks, Lordship.
Oh.
Lordship, also item number 25 from the hearings list. Here we are for respondent number 1. If this matter can also come up after 3 weeks.
Have you informed the
Your Lordship.
applicant?
Lordship.
Oh, yeah, okay,
Yes.
similar order, yeah?
Lordship.
Similar order, after 3 weeks, huh?
Much obliged, Your Lordship.
Lordship, also item number 20. Here we are for the respondent number 1. We have instructions to appear on behalf of respondent number 1. We'll be filing our wakalatnama during the course of the week.
Have you informed the applicant?
Item number 20.
20.
We'll be filing our wakalatnama.
Wakala, not yet filed.
Yes, Lordship.
Okay.
For respondent number 1.
Who is for the applicant? Not appearing. Applicant, let us wait for some time.
Yes, Lordship.
Hmm.
Obliged, Lordship.
Yes,
May I please, Your Lordship?
Yes.
Lordship, I beg to mention hearing item number 28 and 37, Lordship. Lordship, I have the consent of the other side. Moreover, Lordship, due to paucity of time, as there is a meeting today, these items.
27 probably someone has already mentioned.
28, Lordship.
Okay, 28.
28 and 37, Lordship.
28 and
37, Lordship. Hearing list,
37.
Lordship.
Okay,
Lordship, if these matters may be listed after 3 weeks, Lordship.
okay. Mr. Devnath.
Lordship, for the
Land
applicant,
Counsel for the
Lordship.
petition. Applicant. The respondents are also.
I'm
present.
for respondent number 4, Lordship.
Okay. Adjournment of the case. Listing is, listing the matter after
Lordship, 3 weeks.
3 weeks, okay. The prayer not objected to by the Land Council for the respondent. Accordingly, the prayer is allowed, list this matter after 3 weeks, 28 and
28 and 37, Lordship.
37.
Lordship.
Please, Lordship.
Obliged.
May I please, Lordship?
Yes.
Lordship, I beg to mention item 33 on
Yes.
behalf of Mr. Kaliao, counsel for the appellant, Lordship.
Hmm.
Lordship, let this matter come up after 2 weeks, Lordship.
Okay, Mr. Kobe. For the appearing on behalf of Mr. Tali Ao, Land Council for the applicant.
Lordship,
Praise for listing this matter after
2 weeks, Lordship.
2 weeks.
For 2 and 3, Your Lord.
Okay. Mr.
I'm sorry. Your Lordship.
For the,
Respondent number 2 and 3.
okay, for respondent number 2 and 3 is also present. Yes, prayed for comment. List this matter after 2 weeks.
Obliged, my lord.
May I please, Your Lordship? Lordship, I beg to mention item number 21, 22, 24 on behalf of my seniors and younger. Lordship, this matter may kindly be listed after 1 week.
Okay, Mr.
Noklay M.
Land Council appearing on behalf of Mr.
Sandy Younger.
Santiago.
Yes, Your Lordship, and I also pray that my senior name may kindly be reflected in the cost list.
Just a minute. You are for the petitioner.
Respondent, here's for
Respondent number 8.
Respondent number 8.
Yes, Your Lordship.
Who is for the petitioner?
Lordship, I'm for the petitioner.
Okay, you have no objection.
Lordship, as you are aware that this matter was already, the hearing was almost concluded. So,
They were supposed to,
yes,
right.
Lordship.
Okay, Mr.
Lakni from Lordship.
Counsel for the petitioner is present. Okay, Mr.
Lordship, I'm appearing for respondent number 6 in
Okay.
WPC 58 of 2017 and contempt petition 23 of 2022, Lordship.
58, okay. You are Mr.
Noklay M.
Appearing on behalf of Mr. Satyanga, counsel for the respondent number 8, praise for adjournment of the matter. When do you?
Oh,
when-
one week time.
Okay, adjournment of the matter for a week.
And may I please, Lordship, no more further adjournment, Lordship.
Okay. Miss
Apila something. Lordship.
Apila, for the respondent number
6 in
6 in
WPC 58 of
58
2017
is also present. Stop.
and COB 23 of 2022, Lordship, as respondent number 2.
Okay. Age prayed for, comma, list is made after a week. However, it is made clear that thereafter there will be no more further adjournment. Okay. We are not fixing, huh? Okay.
Lordship, it will be better if the matter may be fixed, Lordship.
Next week it will be listed. Okay.
Lordship, in fact, we are yet to obtain the signature.
And probably it was made clear on that day also. He has undertaken that it will be done within 2 weeks. Let us see.
Lordship, my humble submission, if in that case, if we can fix the date.
Now, probably. Okay, so next date will be
September 3, Lordship, if that can be fixed, Lordship, because the next week, some fixed matters are there, Lordship.
September
3, Lordship, that is 3.
3.
Steve.
Okay, is prayed for. Comma, list is matter on 3/9. Okay,
Obvious,
clear.
Lordship.
May I please, Lordship.
yes.
Lordship, I beg to mention item 9. I'm appearing on behalf of Mr. Gauhati, CJC, for all the respondents. Lordship, I pray that this matter may be listed on 2nd September.
Second,
September.
okay. Mr. Ailam, Nongchalan counsel for the petitioner is present. Miss
This is Nagiso,
appearing on behalf of,
all the respondents.
okay. Praise for listing this matter on 2nd September, to which Mr. Ailam Chalan counsel for the petitioner has no objection. Accordingly, the prayer is allowed. List this matter on 2nd September. Okay,
Pledge, Lordship.
May I please, Your Lordship? Lordship, I will mention item number 7.
item.
7, Lordship.
Hmm.
Lordship, as per the direction of this honorable court, I've taken steps through the step on respondent number 2. Lordship, and I'm yet to file my affidavit. So kindly list this matter after a week.
You are for the petitioner.
Yes, Lordship.
Okay. The steps taken by way of Dusty.
Yes, Lordship.
Okay.
As per the order dated 29/7/2024.
Hold on. Okay, Mr.
Mr. Kachish, Lordship.
Submits that he has taken steps upon the respondent by Dusty Service. However, the affidavit to that effect is yet to be filed. Accordingly, pray for some more time for filing affidavit. The prayer is allowed. List is made after
After a week, Lordship.
a week. Okay.
Obliged, Lordship.
Yes, my lord, lordship, item number 32, lordship, on behalf of MS Ayemi, lordship, and grant list the matter next week. After 1 week, lordship.
Okay. No objection.
No objection.
Mr. Mika Ailan, counsel for the petitioner is present. Mr. Angami, appearing on behalf of respondent number,
State respondent,
state respondent, praise for listing this matter after a week. The prayer is allowed. List this matter after a week. After a week.
Yes, Lordship.
Okay.
Lordship.
Lordship.
May I please, your lordship?
Yes,
I beg to mention item number 34.
yes.
Your lordship, my senior has some personal difficulties today. So if the matter can be fixed after 3 weeks, if
Okay, Miss
it is on your solo.
submits that senior is out of stations
Your
and
lordship, she has some personal difficulties
okay,
today.
has some personal difficulties today and prays for listing this matter after 3 weeks. The prayer is allowed. List this matter after 3 weeks.
Much obliged.
Okay. Yes, Mr. Ngami, I have informed 29:30. Could you,
Okay.
have you informed?
No, Lordship, could not locate them.
They are not present.
They may be in court one, but
Okay, this is hearing matter otherwise.
yes. Lordship. Lordship, my prayers for listening next week if,
Okay. Mr. Ngami, counsel for the respondent. State respondent, prays for listing this matter after
1 week, Lordship.
a week. The prayer is allowed. List this matter after a week. Okay.
Pleasure, Lordship.
Please, your Lordship. Lordship, item number 20.
Item
Item number 20. Lordship,
20.
the petitioner, she's a outstation lawyer.
My lord, I am appearing for item number 20, my lord.
Okay.
If 3 weeks time may be granted, we'll be filing our
You are for?
vakalatnama. We are for respondent number 1.
Respondent 1.
Yes, Lord.
So your prayer
My
is
lord.
This matter can come up after 3 weeks, Lord.
for
We will be filing our vakalatnama this week.
Wakalat number noted file.
Yes.
So now the advocate is appearing for the first time. They are going to file affidavit, Wakalat nama
For
My
respondent.
lord,
next time. Okay.
my lord, my prayer, my lord, only a date may be fixed, my lord, any date, my lord.
So Ms. Sumi Kakatilana counsel for the applicant is present. Mr.
No, on behalf of respondent number 1.
Okay, appear on behalf of respondent number 1. So is prayed for by the Lana counsel for the party. List this matter. After 3 weeks would be. 10 September.
Yes.
10th.
My lord,
Okay.
Obliged, Lord.
my lord.
For motion, item number 1.
May I please, your Lordship.
Yes.
Your Lordship, the instant application is filed praying for amendment of para number 2 in the contempt petition, your Lordship, as allowed by the order dated page number 8, your Lordship, the order, your Lordship, 0807/2024, your Lordship.
Okay.
Lordship, copy have been served to the government, your Lordship. A simple prayer to amend the
Anyone appeared on behalf of the contempt now?
Lordship for respondent number 1, Enangami have appeared, your Lordship.
Hmm?
Enangami, your Lordship, government, your Lordship.
Already appeared earlier.
For 1, your Lordship. For 2 and 3, they are yet to appear, sir. Lordship, if I may be allowed to take steps upon respondent number 2 and 3, your Lordship.
Have you taken steps earlier?
Yes, your Lordship.
Copy already served.
Lordship. If I may be allowed to,
After that, you want
after the amendment, your Lordship.
so then it.
Simple prayer, your Lordship.
It was allowed earlier.
Yes, your Lordship. By order dated 0807, your Lordship.
8.
0807, your Lordship. By the page number 8, your Lordship, of the application, your Lordship. The direction was to file an application, your Lordship, for necessary changes, your Lordship.
Mr.
I am sorry, your Lordship.
Clara counsel for the applicant. Clara. By an order dated 8/7/2024. The petitioner was allowed to make necessary changes in paragraph 2 of the contempt petition. Start. By filing this, the applicant is proposing to amend the paragraph 2 in the contempt petition. What is the number?
9, Your Lordship. Contempt 9 of the 2024. Your Lordship.
Contempt petition number 9 in 2024. By the. So what is the difference?
Lordship, there was one typographical error, Your Lordship.
Okay.
Instead of commission appointment, it was type as regularization, Your Lordship. Only that, Your Lordship.
The following, huh? And then type this paragraph, huh? This paragraph, page 4, in that paragraph, huh? This we want to replace. The prayer is allowed. The petitioner say file. So you have to file then recast petition.
Your Lordship.
Okay. File the amended petition. Huh? Within a week.
Lordship, within a week.
Okay. Start, huh? And serve a copy to the respondent.
Lordship. Lordship, if I may be allowed to take fresh steps upon respond number 2 and 3, Your Lordship.
Okay, and take it. Then you first correct it.
Lordship.
File the amended petition. Okay. Will allow. Okay.
Lordship.
With above this, I stands disposal. Okay.
Much obliged.
For admission item number 2.
May it please, Your Lordship.
Yes.
So this revision petition is directed against the order dated 28/2/2022 passed by the Principal District Judge Dimapur in IA Civil number 32 of 2021 arising out of Civil Suit number 4 of 2022. Whereby the application filed with the present petitioner who was the defendant for dismissal of the suit has been rejected. A very long pending issue, and in between the parties several cases are pending before different court in India. In the meantime, during pendency of this proceeding, both the parties have amicably settled the dispute outside the court. And to that effect, they have executed a consent term. And as per the consent term, they have agreed to file an appropriate application before the Dimapur court for decreeing the suit on compromise. So in view of that, this matter may be closed and the interim order passed earlier may be vacated also. So we'll file application before the Dimapur court. This is the copy of the agreement executed by both the parties.
Okay. You're for the petitioner.
Yes, Lord.
So you want to withdraw?
Not withdraw, close the petition in view of the compromise arrive in between the parties. Because there are two set pending, one at Dimapur and one at Gujarat. And the Gujarat suit has already been decreed on compromise in view of this agreement. And another matter is pending at Delhi High Court that is also withdrawn by us.
Mr.
As the
Counsel for the petitioner submits that the hard Mr. and the counsel for the petitioner and Mr. appearing on behalf of of
Respondents.
respondent.
Respondent plaintiff.
So,
I am the petitioner defendant
okay,
and he's for,
so respondent,
yes, lordship.
okay. Stop now. Mr. M. Duttu, counsel for the petitioner,
Yes, Decker.
Hmm?
Yes, Decker.
okay. Yes. Yes,
Decker.
Deka, sorry.
Yes.
Counsel for the petitioner. Submit that the matter has been amicably settled between the parties out of court on
On 26/2024.
6/2024. Stop, huh? And some is said the matter may be closed. And in view of the above settlement, the matter may be closed. And some is that the matter may be closed in view of the above settlement. Dated 26/2024.
Yes.
Okay. The Mr. Procedural, counsel for the respondent has no objection. Start. In view of the above, this matter stands closed in terms of the settlement dated 26/2024. Okay. Accordingly, the matter stands
Close.
closed. Okay.
And we will file the compromise application before the learned lawyer court below.
You take steps there. Okay.
Obliged.
For admission, item number 6.
Six words. Probably someone mentioned already,
No, your lordship.
but not mentioned.
Not mentioned, no? 6.
Okay.
My lord, process has been taken, steps has been taken, my lord. This is the 2nd July communication. Lordship, this matter pertains to regularization of a employee. So now we have taken the initiatives now. Process is like that. It has to originate from the department, and from the department, it has to go to the finance. From the finance, it has to come to the BNR department, Personnel and Administrative Reforms Department. And after concurrence is taken, what we do is it has to go to the state cabinet for approval. Now that it has been placed before the cabinet secretary. Now, when the cabinet says sits, it will automatically approve, because all total formalities has been completed. So now, your lordship may allows me some time.
Mr. himself.
I'm sorry.
Counsel for the petitioner. Start. Mr. Mohan Chenlan, senior government advocate. Appearing on behalf of the state respondent summits that all formalities has been completed for compliance of the order of this honorable court for regularization of the petitioner.
No, yes.
However, now, the matter has been submitted before the cabinet for approval
Yes, yes,
and praise for some more time.
yes.
Okay.
Lordship, just maybe come about 8 weeks, because it will definitely take time.
Before the
Concentrate.
cabinet for approval, which is likely to take some more time. Therefore, praise for further 8 week times for full compliance of the order. So the prayer is allowed. Okay, list is matter after 8 weeks. Age break for list is matter after 8 weeks.
Obliged, Lordship.
For admission, item number 10.
My praise Lordship.
Yes.
My Lord, this is a regular bail application. My Lord, in this case, as noted, it is of 177 days in custody. My Lord, who was arrested on 26th February 2024. My Lord, in this case, prior to the arrest of the alleged accused person, 2 persons were apprehended, and in that connection was apprehended later on. The actual fact of the case is that, my Lord, in this case, the earlier 2 apprehended persons, prior to the arrest, two persons were arrested prior to the arrest of the present accused person.
Okay.
So in this two accused person, they came to his house, the present alleged accused person. They kept their belongings in his house and they went away. And then the present accused person, being a known fellow to them, in good faith, he had kept their personal belongings in his house. Later on, he found out that they were arrested. And then after the arrest, the police personnel came and then he was also apprehended when they came to seize their articles back. And as per the allegation in the FIR, some drugs were found inside the bag belonging to those persons who were apprehended earlier.
21C.
21C, yes.
Okay, so scanned copy of the CD was called for.
Yes, my lord, I have received. My lord, I'm informed that charge sheet is yet to file because they are waiting for FSL report.
My lord, already 177 days as of today.
177 days.
Yes, my lord.
So not yet 180 days.
Not yet.
Not yet.
So what do you do?
My lord, considering long detention period, this honorable court may be pleased to enlarge the accused on bail. And then the alleged accused person, his wife, she just recently, just 5 days ago.
What is the statutory period? 180.
180 days, my lord.
Wait for some days, some more days, then 3 more days.
My lord, considering the health of the wife also.
This matter on Friday.
My lord.
My
Friday
lord.
or Thursday. Thursday it will be, I think, no.
My lord, as per section 36A, the days may be increased to 1 year, my lord.
Yes.
Not yes.
Okay, not 180.
Yes, not only 180. It may increase to 1 year. But my lord, here I have a serious objection, my lord.
Okay.
Because
And
the
if it is
cease,
360.
yeah,
Then it's
36.
a problem. And then this is 21C.
Yes, my lord.
It will be difficult. We'll have to see them. 161 statement is also there. PP.
My lord, in the statement of the accused is, I have flexed my lordship, may kindly see page number 6.
Page 6 is just.
Page 11, page 11.
accused.
Yes. Statement of accused.
Let us see first the statement of the other witnesses who has implicated the accused. What is this page 6? Recovery.
Yes, my lord. Statement of other accused starts from page 9, 9, 10. Page 9, 10, and 11.
Just a minute. The recovery one is page 6.
Yes.
He knew it from the very beginning. So who else has implicated that he is involved? Among
By
the-
accused number 2,
Okay, page,
page number 10.
the name of the present accused is
Alimuddin.
Alimuddin.
Yes, ma'am. It is in the last paragraph.
So same statement is. Mm. It is not that he did not know, he knew it from the very beginning and sent the photographs also to the client, to the buyer and customer. Difficult. Mr.
Vinod Kashmi.
Land counsel for the petitioner. I've also heard Mr.
E.T. Bokma.
Nana PP for the state of Nagaland. This is a bail application filed under section 439 CRPC, praying for grant of bail to the accused Alimuddin, who has been arrested by which police?
West Police Station, Dimapur.
West Police Station, Dimapur, in connection with West PS case number 13/2024 under section 21C of NDPS Act, read with 34 IPC. Start. The case of the petitioner is that based on the dual motor fire lodged by one HAB Pepuso CKG SOT Dimapur before the officer in charge of West Police Station, Dimapur, Nagaland. The case was registered, case being West PS case number 13/2024 under section 21C NDPS that are the read with 34 IPC was registered and investigative unit staff. Initially, two accused persons were arrested.
Yes, my.
The further case of the petitioner is that initially two accused persons were arrested. And on the basis of the disclosure statement given by those accused, arrested accused, the police visited the special operation team raided the house of the accused Alimuddin and on search being made, search being conducted. 26 plastic soap cases containing 317 grams of suspected brown sugar was recovered, along with WYABA 192 tablets weighing 19 approximately. And seized. Along with the arrested accused staff. Okay. The scanned copy of the this should be in the scanned copy of the case that it has been produced by Mr. Lana PP and I perused the same stuff. The record reveals that the accused is involved in selling of the second-hand vehicle and also involved in the supply of the drug, involved in the selling of the contraband drug stuff on the day of the on the record further reveals that on 26/2/2024. Based on the disclosure made by the accused, the police has vegetate. The police has made a search. The police has conducted a search in the house of the accused and recovered the above mentioned 26 plastic soap cases containing 317 grams of suspected brown sugar and WYA BA 192 tablets weighing 19 approximately, which were seized. Hence, so recovered and seized. Stop. The record further reveals that the accused is involved in the drug business since long. Okay. Any case amount was also received from the accused? No.
Pardon, my lord.
Case amount was also received, recovered? No. This was from some other.
From the accused. No, no cash was received.
No cash, my lord.
Good. Okay. The Ghana people submits that the case is still under active investigation. And under the circumstances, the release of the accused would hamper the further investigation of the case and hence object to the grant of bail to the accused. Hence raise objection to the grant of bail to the accused. Stop. Considering the nature of the allegation that are made against the accused and the material recovered from him, and also the other incriminating materials found against him. And also considering that the case is still under active investigation. I am not inclined to grant bail to the accused at this stage. Accordingly, this bail application is rejected. Okay.
Obliged, my lord, much obliged. For orders, item number 12.
May it please your lordship.
Yes.
My lord, the last time steps were taken on the pro forma respondents.
Yes.
And we have also filed the affidavit of due service, and the service is complete. So my humble submission is that your lordship can take it up for final disposal. Matter is otherwise very simple, arising out of an application filed under Order 7, Rule 11. Now, if your lordship will permit me, I can just praise the prefatory facts, my lord.
So this, who is for the other side?
Other side is Mr. P.B. Pal. Last time he got this posted as per his convenience only. And today there is no information to me whether or not he would like to continue in the matter. But then for the fact that the matter is pretty old, of 2011, and 13 years have gone by. So therefore, and on the last occasion also, for one adjournment that I sought, there was a cost of 20,000 that I had to pay. Only one adjournment, my lord. Your lordship can see the order, 29th July, no? Sometimes 20 June. Sometimes in the month of June, my lord, an order by Justice.
Somebody heard earlier.
Yes, and it was by Justice Sema's order.
It seems.
Yes.
It was extensively heard.
Extensively heard, but thereafter it was released from Parthard. It was released from Parthard. The matter is very simple, my lord. I filed a suit before the trial court, seeking declaration of my right, title, interest, and other relief, and permanent injunction against the defendants. Now, in that suit, the defendants come and they file an application under Order 7, Rule 11. Order 7, Rule 11 is for rejection of plaint. Now, Order 7, Rule 11 lays down certain particular grounds on which an application under this particular order is maintainable, that your lordship knows. They specifically take a plea that my suit is barred because it is barred under the application of Assam Land Revenue Regulation.
Okay.
Because Assam Land Revenue Regulation bars this case. That is the ground taken. Now, their
Assam Land Revenue
regulation
is applicable?
Is applicable to state of Nagaland. Now, the interesting thing is that I'll just show the apparent non-application of mind by the learned trial court. The application is filed by them under Order 7, Rule 11D. Your lordship will kindly see the application in the compilation at page 208. You can take it. 208, your lordship will kindly see. An application filed under Order 7, Rule 11D, read with 151 of CPC for rejection of plaint filed by the respondent plaintiff in title suit number so and so. Am I clear to your lordship now? So this is for 11D. And kindly see the impugn order passed by the learned court below. Learned court below's order is page 251.
Yes.
the applicant's defendants filed this application under Order 7, Rule 11A.
Okay.
The entire approach is wrong. Now, if I can show your lordship citizen, show your lordship the CP relevant provisions of CPC, that is Order 7, Rule 11A and Order 7, Rule 11D. Order 7, Rule 11A says about cause of action.
Order 7, Rule 11,
A.
cause of action.
It says about cause of action.
Hmm.
I'll just read it out to your lordship. May I read it slowly? Hello.
Yes.
By the time the book comes.
Hmm.
Order 7, Rule 11 says rejection of plaint. The plaint shall be rejected in the following cases. A, where it does not disclose a cause of action. Now, the application which the defendants filed before the trial court, they do not say that my plaint does not disclose cause of action.
Hmm.
The ground is entirely different.
Hmm.
The ground is that clause D.
Hmm.
Clause D says, where the suit appears from the statement in the plaint to be barred by any law.
Hmm.
Am I?
Different, yes.
It's different. The application is filed under 11D, saying that my plaint is barred by certain law. And what is that law? That is Assam Land Revenue Regulation. That is the case set up by the defendants.
Hmm.
But the trial court proceeds on the basis that as if this is an application under Order 7, Rule 11A, whereas it is not. So the very approach of the learned trial court in deciding the Order 7, Rule 11 application, my lord, that is wrong. This is my first and foremost ground before your lordship. Now, if your lordship will kindly see what is the purport of their challenge. Why did they file this application under Order 7, Rule 11D? They say that in the plaint, I have challenged the settlement order in favor of them, in favor of the defendant. And they say that because there is a provision 154 in the regulation, Assam Land Revenue Regulation, which says that in respect of settlement orders and other things, my lord, there will be no civil suit, no civil court shall have jurisdiction. And therefore they say that my suit is barred by time. I'll just read their application here for lordship. We will kindly come back to page 208 once again. The grounds of their application are from page 210. It's basically, my lord, it's a case of remand. Apparently, my lord, the trial court has committed an error, which is apparent on record. They filed an application under 11D. Trial court has approached the matter from the perspective of 11A. It cannot be my lord, cannot be an order by which my plaint can be rejected. Now, if your lordship will kindly come to page 210, they say the grounds. Paragraph 3. Paragraph 3.
Yes.
CPC.
Yes.
Also, please give the Assam Land Revenue Regulation.
Now,
Paragraph 3.
we have to go. Can we hear in absence of the other side?
My lord, actually, the law in Order 7, Rule 11 is that only the plaint has to be taken into account, not even the written statement filed by them,
Right.
not even the averments made in the Order 7, Rule 11 application.
Hmm.
It is only a matter between the court and the plaintiff.
Hmm.
Well, like if necessary, my lord, I can right now submit a judgment, my lord, on this point. That it's a purely question between the court and the plaintiff, because their defense, their written statement is not to be looked into. Their application is also not to be looked into. There is a judgment by Justice, Honorable Justice Ranjan Gogoi, my lord, while his lordship was there in the Supreme Court, my lord. That is a judgment of 2015. The state, I'll supply, my lord, the copy to your lordship. The particular observation is there. It is only if the averments in the plaint ex facie do not disclose a cause of action, or on a reading thereof the suit appears to be barred under any law, the plaint can be rejected. In all other situations, the claim will have to be adjudicated in the course of trial. So it is not to be, I mean, their defense is not to be taken into account. And the particular observation, your lordship will find in paragraph 6, the claim of the plaintiffs with regard to the knowledge of the essential facts giving rise to the cause of action as pleaded will have to be accepted as correct. At this stage of consideration of the application under Order 7, Rule 11 of the Rule 11, the stand of the defendants in the written statement would be altogether irrelevant. So practically, I'll supply the judgment.
Got it.
Your lordship has got it. Yes. Your lordship will kindly come to page 333, paragraph 5 and 6.
Yes.
Paragraph 5, your lordship may kindly see.
Yes.
Rejection of plaint under Order 7, Rule 11 of CPC is a drastic power conferred in the court to terminate a civil action at the threshold. The conditions precedent to exercise of power under 711 therefore are stringent and have been consistently held to be so by the court. It is the averments in the plaint that have to be read as a whole to find out whether it discloses a cause of action or whether the suit is barred under any law. At this stage of exercise of power under Order 7, Rule 11, the stand of the defendants in the written statement or in the application for rejection of the plaint is wholly immaterial. I hope, my lord, I have been able to convey it to your lordship.
At the stage of exercise of.
Yes. So even if your lordship is taking up the matter, my lord, well, it is a matter entirely between the court and the plaintiff.
Yes, it's only the plaint is to be.
Yes, only the plaint.
Yes.
Now, if the so naturally their defense or their averments have got no relevance. So therefore, coming back to the case in hand, my lord, where they had filed an application under Order 7, Rule 11D, how could the trial court approach the matter from 11A? Because 11A is not their case.
Right.
It is not their case that the suit is barred by suit does not disclose cause of action. It is their case that it is barred by Section 154 of the Assam Land Revenue Regulation.
Yes.
Page 250, your lordship I was just referring, my lord. Page 210. In 210, my lord, their specific ground your lordship can see.
Yes.
Paragraph 3, that the petitioner state that on a plain reading of the facts contained in the plaint and the documents filed and impugned by him would clearly establish that the title suit of the plaintiff is hid by the provision of Order 7, Rule 11D and Section 151 of CPC inter alia on the following grounds. Now, the first ground.
Now they are saying D.
Now,
sorry, D. Yes.
D. It is their case that it is D.
Yes.
Trial court has approached it from a wrong direction.
Right.
Now, the ground A, it is absolutely clear from the prior portion of the plaint that the settlement of land consisting of 6 lesas in favor of the Jame Masjid Committee, Dimapur, by order number so-and-so, issued by the Deputy Commissioner, has been challenged by the plaintiff. The respondent plaintiff also reflected that the same order has been taken as one of the cause of actions for filing the title suit under the provisions of the Assam Land Revenue Regulation 1886. Certain types of disputes are exempted from the cognizance of civil court. The issue in regard to the validity or effect of any settlement cannot be questioned before the civil court under the provision of Regulation 1886. Since the order number so-and-so is purely a settlement order made in favor of the Jame Masjid Committee, its validity has been questioned by the plaintiff in civil court. The title suit number so-and-so is barred under Order 7, Rule 11D. So this is the only ground. And at the cost of repetition, my lord, I can read out the entire other grounds, my lord. Your lordship will find that what they are saying is essentially that it is barred by 154. Now, section 154 of the Assam Land Revenue Regulation, my lord, that is a subject matter which they had praised before the trial court, and the trial court has said that it is barred. Now, try 154, I'm just, if your lordship is having that book, Assam Land Revenue Regulation.
Yes.
154, your lordship will see. Matters exempted from cognizance of civil court. Is this Assam
154.
154. Regulation 154.
It's rules and the regulation.
Your lordship I can give this book, my lord.
Okay.
I'll find
I
it.
think it's same, all the same.
Maybe the page is little different. 154.
This is the.
Now this 154.
Yes.
Now this 150, this is the basis of their saying. That see, your lordship now will see clause 1 and clause 1A and C, settlement order. Under 154, 1C, 1A and 1C, your lordship will see. They mean to say that because of this particular provision, the plaint is not maintainable. And the trial court's finding, the lordship will find here. Trial court's findings are also very weird, if I may say so, my lord. And this particular provision has been interpreted by this honorable court in numbers of decisions, my lord. Only 2 decisions I'll cite before your lordship, the things will be clear. Has your lordship now seen 154? Now this 154 has been interpreted by this honorable court in number of decisions right from 1989. There is a full bench decision of this court. Subsequently, there are umpteen number of decisions saying that this 154 does not bar civil suit. I'll just place one judgment and see one. 1991. No. This is 89. No, not this one. This one. Huh?
So they are, so they have come on 154 A and C.
A and C.
Question as to whether, question as to the validity or effect of any settlement.
Yes. Since I have challenged the settlement in this suit, my lord, that's why they say that 154 will bar the suit.
Or as to whether the condition of any settlement are still in force. The formation of the record of rights or the declaration.
Now, right on the point, my lord, I am placing a judgment of this honorable court. Your lordship may kindly see this judgment below, paragraph 11. Paragraph 11, your lordship will kindly see. That will be at page 3.
Yes.
Mr. Singh has urged that the plaintiffs are not entitled to get a decree for cancellation of the mutation in the names of so-and-so contesting defendants in view of section 154(1)(c) of the Assam Land and Revenue Regulation 1886, which runs as follows. Now, 154 is quoted, my lord, there. Mr. Acharya, learned counsel, has urged that this law regarding preparation of revenue records during the settlement operation, and that the civil courts is the best authority to decide the title and accordingly directed cancellation of the mutation in land revenue record. In this connection, I may quote below section 62 of the regulation, which runs as follows. My lord, 62 also your lordship can see, that is also there in the book. Nothing contained in this chapter, this is very important, lordship. Nothing contained in this chapter and nothing done in accordance therewith shall be deemed to preclude any person from bringing a suit in the civil court for possession of or for declaration of his right to any immovable property to which he may deem himself entitled. Render entry of any land in register under this chapter as revenue free and admission on the part of the right of the person in whose name the land may be entered, or an admission of the validity of the title under which the said land is held revenue free. Well, this is 62, regulation 62 is quoted. And now, my lord, the final conclusion. I therefore find considerable force in the submissions of Mr. Acharya and hold that civil court is the best authority to decide the title over the property to any person and can also direct cancellation of mutation in the revenue record. I further hold that section 154 of the Assam Land Revenue Regulation is not a bar for issuing such a direction for cancellation. It is very clear, my lord. And the reason is that, my lord, this has been the consistent decision of this honorable court. And next judgment I will file, my lord. Now, this was 1991. There is another judgment, 2002, my lord, 2002, 1 GLT 176. Here, your lordship may kindly see second page, my lord. Judgment by Justice Jain Sharma. Paragraph 3. I have heard Mr. S.K. Medhi, learned counsel for the appellant, and Mr. Basar, learned counsel for the respondents. Following are the substantial questions of law. Whether the suit is barred by section 154(1) of the Assam Land Revenue Regulation 1886. That was the specific question. Paragraph 4, your lordship may kindly see. Regarding the first question, there is no need to discuss it, as a suit for declaration of title and injunction is never barred by section 154 of the Assam Land Revenue Regulation. Has your lordship got it? The second question also requires no discussion, inasmuch as the Land Revenue Regulation has given a right to a person to cancel a mutation obtained illegally, but that does not mean that civil court shall have no jurisdiction to give a declaration with regard to that. That is what was prayed for by the plaintiff, and the appellate court rightly granted that pair. In that view of the matter, there is no merit in the second appeal, and the same shall stand dismissed. Now, the second matter, in that case, my lord, the trial court had gone into the matter. Now, kindly see, my lord, the notable two things. If I am asking for, as per this judgment, 2002 judgment, my lord, if I am asking for a declaration and for permanent injunction, my lord, then the suit cannot be said to be barred. Now, I'll show from the record, my lord, what was my prayer before the learned trial court. Your lordship will kindly see the prayer at page 45. Prayer in the suit at page 45. Has your lordship found it, my lord?
Page 45.
Yes. The plaintiff therefore prays for. This will page 45, my lord, this is just below the words schedule 2.
Okay.
Just below the words schedule 2. The plaintiff therefore pray. Has your lordship got it, my lord?
Yes, yes.
Now, first see clause A, drawing decree and declaration and confirmation of established and absolute lawful occupational rights, titles and interest. B, to declare the grant so and so. C, to declare. D, to declare. My lord, these are declarations that I have sought for. And kindly see the next page, clause G. Prayer clause G. To grant and issue perpetual injunction. So, my lord, by the latest judgment that I have cited before your lordship, if I am asking for declaration and injunction, my lord, then it cannot be said that 154 bars it. Because it is the civil court which is the best court to decide it. Am I clear to your lordship? But the entire thing has been missed out by the learned, because the learned approach of the learned trial court is quite contrary to the records. They wanted that this should be dismissed on the ground of 11D. Trial court approaches as if it is a case under 11A. So this is apparently, my lord, the expressing, my lord, the order of the trial court, impugned order passed by the trial court is wrong and it's illegal because it is against the decisions of this honorable court. Consistent view of this honorable court, my lord, I have shown two judgments. There are many others.
So their prayer is
in the prayer at page 214, your lordship will kindly see.
Yes.
Admit the instant petition and issue notices to the respondents. After hearing the case, be pleased to reject the plaint filed by the respondent plaintiff under the aforesaid provisions of law. How can it be barred? And trial court's observation, your lordship will kindly see. And very interestingly, my lord, the judgment which I am now citing before your lordship, one of these judgments was pleaded by me in my objection. If your lordship will kindly come to page 235. I specifically took a plea that this is not barred because of the law laid down by this honorable court. Page 235, your lordship will see. Serial 4. Serial 4 is a citation, my lord, which I have now just shown to your lordship in 1991 judgment. 1991 1 GLR 236. The first judgment that I had shown to your lordship. Yes. So this was my specific plea before the trial court, and in the trial court's judgment, my lord, there is no discussion whatsoever.
Where is the impugn order?
Now, impugn order starts from page 250. But the operative part, your lordship will find at page 255. There is absolutely no discussion why of this particular decision.
Any issues?
Nothing. No, not even the issues were framed.
Issues not from.
No.
Probably.
Your lordship will kindly see. It's a judgment running into 5 pages, my lord. 4 pages, if I may say so. From page 251 to page 255. 4 pages. No framing of issues. No discussion of the defense taken by me. And simply saying that this suit is not maintainable. If necessary, my lord, I can read out the entire judgment to your lordship.
It's fine, because probably today, in absence of the other side, it will be difficult again.
But because of the law, my lord, that I have cited, it's what I am wanting is only a case of remand, my lord. And the Honorable Supreme Court has also said that it is not their defense that have to be looked into, nor even their statement in the WS. They state they did not file
That is true, but then once the need to hear them once only.
In that case, my lord, your lordship, since I have already made my submissions, the lordship can keep this matter as part and fix it on 29th. I'm coming from outside, my
We'll
lord.
fix it on 29 without saying it as a part. We'll fix it on 29. I'll be there only.
29th. And kindly consider my plight, my lord. For one adjournment, my lord, I had to pay 20,000 rupees as cost. At least, my lord, some balancing act has to be there, my lord. They should also now pay something to me. I have been coming all along from Gauhati, my lord. And there is no representation today. Not even a prayer for adjournment. They are not going to be prejudiced anyway, my lord. Because in the trial, my lord, they will get full opportunity of contesting it on merit. Expressing, my lord, on the face of these decisions of this honorable court, and of course the law settled by the Supreme Court.
So your prayer is now?
Now my prayer is to remand the matter because this is a settled law, my lord. Unnecessary, it will wait for further time. This is settled law of this honorable. I can cite other judgments, my lord. My friend has brought out total 15 judgments. It is not required, my lord. Because the same thing from 1989, my lord, that is the consistent view of this honorable court. So 15 judgments, there is no, this is the
beginning and the last one too.
Yes.
Not all the judgments.
So it's a case of remand, my lord. Only I am asking is that, my lord, and your lordship will kindly see the approach of the learned trial court. They filed an application under 11D. Even if I don't argue these points, my lord, I thought it appropriate that I should not hide something from your lordship.
But then when it was heard, probably both parties were heard. When it was kept as a part heard. In the last occasion.
Yes.
Okay. So what had happened thereafter?
Thereafter, my lord, one day I missed out. I had to pay a cost of 20,000 rupees. And today, my lord, there is no, and also, of course, my lord, on that day, a request for adjournment was made on my behalf. That was rejected because they were vehemently objecting to the prayer of adjournment. And today they are absent. There is also no request for adjournment. And otherwise, your lordship will.
What we'll do is we'll fix on 19, and in case they again fail to appear on that day, dispose of as paid.
Your lordship can certainly do that, my lord. But what I am on is that, my lord, apparently, my lord, prima facie from my records, I mean, from your lordship's records, my lord, I have shown that they filed an application under 11D.
Right.
And the trial court has approached the matter from 11A. By what logic, my lord, this order can sustain?
So on that day, we'll go through the judgment and then we'll try to dispose of.
Good. 20. Then your lordship can keep it on 29th.
29. Okay.
And since, my lord, I have made my submission, that's why I was saying that if your lordship can mark it as part heard. In that case, the benefit is that, my lord, it will get some precedence in the cause
We need
list.
to go through the judgment also.
Yes.
Let's just once.
And at one point of time, my lord, my learned friend is also there. I'm making a statement at the bar. They had also agreed.
Okay. For
That-
remaining back.
Yes.
Then what happened?
Then, my lord, this, my absence was there.
Let them be present then. Just once, let them be present. We'll see.
But why I am saying part heard, my lord, in that case, it will get some precedence in the cause list. If the matter is listed high in the cause list, my lord, then there is, because if it is listed very down below in the list, my lord, we do not know, my lord, the matter may not reach. These things are there. So that's why I am saying that if your lordship can mark it as part heard.
Because
Very, very short point, my lord, involved. I filed this suit, they came with an application for rejection under Order 7 Rule 11D. Now, really, Rule 11D does not apply in this case because of these two decisions of this honorable court.
where was the judgment? 250.
250. It's an old pending matter, my lord, of 2011. This was 29th April 2011. The last page, your lordship, 255, your lordship will find the order down below. That is 29th April. Down below, left-hand side.
55.
This is 29th April 2011. 13 years have gone by.
Yes.
Without even going into the merit of the matter, my lord, my respectful submission is that just on the face of it, the first opening paragraph of the judgment, it is not a case under 11A. How do you reject my plaint on the ground of applicability of 11A? So it should go back, and if necessary, my lord, if your lordship is one trying to balance the justice, my lord, in that case, this should go back to the trial court, and the trial court should decide this application afresh.
Right.
Let this application under 11D, let that be decided afresh. Because apparently, my lord, this 11A is not the case set up by the parties.
Why then it is such a simple supposing as you submitted?
Very simple, my lord.
Then why did it take
Now,
13 years?
Here, my lord, previously, my learned friend's father was also conducting the case. He expired. And at point of time, there was some confusion as to which bench this matter will go before.
Okay.
Because at one point of time, it was before the Honorable Division Bench.
Gotcha.
Then thereafter, it was realized that it's not a DB matter, it's a single bench matter. And division bench, your lordship knows, it is not very frequently that division bench is constituted here. So that is how the time has been consumed. And subsequently, my lord, after the matter came back from division bench to the single bench, my lord, my learned friend's father, who was the conducting counsel, he expired. So
Probably,
so my alternative submission will also be, my lord, this, that if your lordship is trying to balance the rights of the parties, my lord, let this civil miscase which the learned trial court has dismissed, let it go back to the trial court and trial court will decide it afresh. This will no way prejudice anyone.
you earlier submitted a list of dates.
Yes.
No. So it was submitted.
Yes. List of dates have been submitted, written arguments have been submitted.
Written argument also.
Also, both the parties. Everything is complete, my lord. It is only because the matter was released from the part-heard, my lord, that's why the judgment could not be delivered. And the reason of releasing it for part-heard was my absence, my lord. I could not appear on that particular date.
We'll try to dispose on 29th.
On 29.
Let them be present. Please.
Okay. Okay.
So in the meantime, on that day, we'll just seek the judgment also, judgment
Yes.
and order as before disposing of.
My lord, because
Have they, whether the learned trial court, it was not by mistake, this 11A, not by mistake.
by mistake, I'll say. Because application
No,
I have shown to
in
your
the
lordship.
body of the judgment.
In body of the judgment, your lordship will kindly see. In the body of the judgment also, thereafter,
Because if it is not by mistake, then apparently it appears there was a mistake.
no, if your lordship will know, then consider the pages.
Hmm.
Only 4 pages. Judgment is only 4 pages.
Hmm.
There is no reference in any of the other pages, my lord, about 11A.
Okay.
Judgment is of only 4 pages, my lord.
Hmm.
There is no reference of 11A or even 11D in any of the pages.
Okay.
So what I'm on is, my lord, it's entirely a wrong approach that the trial court has taken. And therefore, if the matter is remitted back to the trial court, without going into the merit of the matter, then also, my lord, my rights will be protected.
And probably he did not discuss about the, I think, rejection of the claims.
No, nothing. Nothing.
So that is why it appears that the civil court cannot interfere into the competence of revenue authorities.
Yes.
So he is discussing about their role in that.
Yes. And the
Not
reason
11
is
not
that, my lord,
11A.
reason is 154.
Hmm.
Reason is 154 because 154 has been praised into service by them,
Hmm.
saying that this bars the suit. Now, the leading judgments of the honorable court that I have shown to your lordship, if your lordship will see their application also, in their application also they say that it is barred because of the application of Assam Land Revenue Regulation. And Assam Land Revenue Regulation, the only bar is there in section 154. And in entirety of the entirety of their application, they are repeatedly saying about 11D. There is no whisper of 11A. But the trial court has decided it 11A because last page 255, your lordship will kindly see.
Yes, that's.
About 8th line from top.
Hmm.
Therefore, on the face of record, there is no title document of the respondent.
Hmm.
11D, I am not required to show any title document. In the present suit, there can be no little dispute with the cadastral area in Dimapur on the above facts, except where there is an express provision of law to which no such facts pleaded in the instant claim. Civil court cannot interfere into the competence of revenue authorities in allotment of land unless there is a prima facie commission or omission of curtailing a person's rights in view of the above provisions. Whatever title it may be issued without entry in the revenue authority record, it must be treated as illegal. Now, these observations are again in my favor. These observations are again in my favor because I have challenged the title in my suit. It is unfortunate to see that a permit purported to be a grant under the Assam Assessment of so-and-so Act for more than 72 hours has no record in the revenue authorities. Therefore, agitating after allotment to others cannot sustain as it is a matter of record of rights, not possession only. Besides, it reveals that the respondent plaintiff had filed CS 01 of 2009 on the same facts and issue and rejected by the learned trial court and thereby assailed for review and by review but failed. On the above facts, this court has no jurisdiction to entertain the suit. as rightly pointed out by the applicant defendant learned counsel. Now, CS, this judgment, CS1 of 2009, this was filed by me, but this was dismissed by the trial court on the ground that it did not disclose any cause of action. So I brought a fresh suit because Order 7 Rule 13, your lordship may kindly see. 13 permits me to bring a fresh suit. Your lordship may kindly see Order 7 Rule 13. CPC. Order 7 Rule 13.
Yes.
Where rejection of plaint does not preclude presentation of fresh plaint. Has your lordship got it, Milord?
Yes.
The rejection of the plaint on any of the grounds herein before, that is including ABCD, whatever is there in 11, mentioned, shall not of its own force preclude the plaintiff from presenting a fresh plaint in respect of the same cause of action. So CS 109, CS 01 of 09, about which, Milord, there is reference in page 255, Milord. This plaint was rejected because it did not disclose cause of action. Therefore, I filed this fresh suit. Now, after I filed this fresh suit, they again came back with an application saying that it does not, now this time it does not disclose, it is hit by 11D. There is no bar, there is no legal bar on me. So the entire approach of the learned trial court is on a wrong premise. So therefore, my submission was that in case your lordship is not, deciding the case on the merit, otherwise also your lordship can dispose of the appeal by remanding simply setting aside this order and remanding it to the trial court for a fresh decision on merit.
Let them be present.
Okay.
Mr. Esther, the senior counsel, assisted by Mr. Devnath, V. Devnath, counsel for the applicants. Represents the respondent.
The lordship can indicate that service is complete and matter will be heard there.
It was a the pro forma respondent. Number 13 to 20.
Yes, they have been served, my lord, and we have also filed affidavit of service. It is only for the sake of setting the records straight, my lord. Otherwise, pro forma respondents are not the principal respondents. They are not to be affected either way the case is decided.
So you have filed affidavit to that effect.
Yes. Affidavit also, no? Yes, affidavit is filed. The judgment will not pronounce আলাদা রাখা হবে যেমন private from independent. You know these sequence? No. Sequence is clear. Video record, argument is উপরে depend করবে আমরা যেগুলি দেবো দিয়েছি। Argument যেহেতু নেই সেদিন মেনে দিয়েছি।
It's on, not on record, probably.
It was filed on Friday, my lord, I am told.
Friday.
Last Friday it was filed.
Probably it was.
Maybe it has not been tagged as yet.
Okay.
কোনো filing number বা serial number কিছু?
The Lorry Council for the appearance submitted. He has taken steps upon. He has taken steps upon the the pro forma respondent number 13 to 20. And file and by RG by Dusty Service, by way of Dusty Service, and file affidavit to that effect. However, the said affidavit showing that the petitioner has taken step by Dusty Service is not being taken, but not on record, huh? Stop. Not yet placed on record. Okay. In view of the above. And is paid for by the land council for the applicant, list is matter on 29.
29, Thursday.
29.
My apologies, lordships. Lordship, I'm for the respondents.
You are correspondent.
We will go for a hearing.
As per your convenience, but not today. Since we are of the.
My lord, now that he is here, my lord.
So you're for
He is for the
respondent, not
respondent.
for the pro forma respondent.
No, not for the performer.
Now, my lord, now that
Okay,
he is.
then, just right, huh? After there, Mr. Procedural over the land council. for-
Since it's an orders, I was
Uh,
impatient that it would take him up for a hearing, so
Okay.
that my senior didn't come up.
Correspondent number,
Now, but if he agrees, my lord, it can still be remanded back. If the matter is remanded back,
correspondent.
ultimately, I think it's a
respondent,
case for remand.
huh?
Today, here for today.
Yeah,
No, not today.
okay,
Not today.
okay, on 29.
Okay,
Not today.
no one appears on behalf of the pro forma respondent. The petitioner submits that.
Appellant.
Sorry, the appellant submits that they have taken steps upon the pro forma respondent number 13 to 20 by Justice Service. And also file affidavit showing service of notice upon the pro forma respondent number 13 to 20 by Justice Service. However, the same is not on record. Starter. In view of the above, and on the prayer of the land council for the parties, list this matter. Learning counsel for the respondent.
Respondent,
Yes,
Milord. Respondent 1 till 12.
Counsel for the respondent. List this matter again on 29 will do.
29. 29. And then, okay. Yes, Thursday. Yes.
Okay, 29. Okay, okay.
1 to 12. I think 1 to 11. Oblige me. Oblige, my lord.
For orders, item number 14.
May I please, your Lordship?
Yes.
Lordship, as per the last order, Lordship, the service upon the respondent is complete, Lordship. So as regards service, Lordship, it is complete. And in that eventuality, Lordship, if it can be listed for him.
Okay. Mr. Devnath.
Lordship.
Counsel for the appellant submit says the service. As regard the service, the service is complete,
Lordship.
and the matter is ready for hearing. So you are for
Respondent number 1,
Miss
Ayala Engine.
Counsel for the respondent is also present. Start. In view of the above, list this matter.
Lordship,
So,
after 3
hearing.
weeks, 3 weeks, after 3 weeks,
No, okay, after 3 weeks
oblige, Lordship.
for hearing,
For orders, item number 15.
May I please, your Lordship?
Yes.
With regard to this matter, it has come to my knowledge that your Lordship, respondent number 1, 3, and 4, the then respondents have retired and being replaced by the new incumbent. So I have filed an IA, your Lordship, this morning. So if the matter may be come up along with the IA,
Miss
Aratsla Kips.
Counsel for the petitioner submits that she has filed an IA implementing the new incumbent. However, the same has not been listed today. In view of the above, let this matter be listed after a week along with the IA.
Yes, your Lordship.
Okay,
In the meantime, your Lordship, I may be allowed to make an amended petition also,
which one?
with regard to this continuous amended for the newly respondents.
Okay, no, newly respondent. So that is to be first implemented.
Yes, your
That
Lordship.
is to be allowed first. Thereafter, you have.
Lordship, of your Lordship. Oblige.
Has it come or not? If it has come, no, it hasn't. You have filed today only.
Yes, your Lordship, only this morning. Oblige.
For orders, item number 18.
I have a same praying for this matter, your Lordship.
Same, similar
Yes,
order.
Lordship.
Yeah. Here also you have filed IA.
Yes, your Lordship,
Okay,
for
similar
implementation.
order.
Yes, Lordship. Lordship, yes,
Next week.
Lordship.
Hmm.
Oblige, my Lord.
For orders, item number 19.
May I please, your Lordship?
Yes.
I have taken the first steps upon respondent in complying with the order dated 23/7/2024.
Okay. Mr. Parking Richard Balani, counsel for the applicant. Sorry, it's appellant. Submits that he has taken fresh steps upon the respondent number.
So respondent, my lord.
Okay, respondent. However, the same, the return service is still awaited. Service report is still awaited. So in view of the above, list this matter after
3 weeks.
after 3 weeks. Okay.
For hearing, item number 35.
You have some around little less than 30 minutes. Will we be able to complete today?
It is a short matter.
Short.
Yes, it is a very short matter.
Okay.
May I please your lordship?
Yes, please.
This is in a bill under section 173 of MV Act 1988 against the
You are on
judge.
behalf of the
I am for
insurance
the,
company.
yes, your lordship.
Okay. Yes.
So against the judgment and order dated 31/5/22 passed by MSCD Mokokchung
Yes.
and MSC number 9 of 2020. So, my lord, the respondent number 1 and 2 was implemented as necessary party because they filed a
One is
1 and 2 is
One one is
claimant. Yes, 1 and 2
Two?
is the claimant.
two is
One
also
and-
claimant.
Yes, in the claim petition. So the fact of the case is that on 6/2/2020, about 6 p.m., the deceased was standing on the roadside at Johar, Assam. A Pulsar motorcycle came rush and negligently driven by respondent number 3. So they met with an accident and the deceased was grievously injured and she succumbs to the injuries as a result of which the deceased dead on the spot. So the respondent claimant had filed a claim petition before the motor vehicle claim tribunal Mugokchung. So I've annexed the petition as Annexure A in my appeal petition.
Okay.
So the appellant has filed a written statement and contested the case on merit. So despite of raising the appropriate defense and necessary objection at the time of hearing, while proceeding and disposing the case, without following the basic and fundamental rules and without considering the facts and material documents, the MSCD has disposed of the case on 31/5/2020 in favor of the claimant by allowing 10,75,000
Okay.
as which I've annexed as Annexure C, page 20. So thereafter, the appellant has filed a review petition before the MSCD Mokokchung. First ground was to modify the multiplier, that is from 7 to 5. Because the age of the deceased was 70 years.
70.
70.
What he was doing at the time of his death?
Nothing is mentioned,
Okay.
but
What is the monthly income shown?
monthly income, it was calculated as 15,000
15,000
per month.
So
So actually, in the claim petition, they filed that her age was 63. But when we see the record, death certificate in the Adal Amrit Apayan IT card, her age was 70. So we've tried to modify the multiplier from 7 to 5. And then the second one was
so
to
multiplier is 7.
actually, and they've calculated a 7, but actually it should be 5.
It should be 5.
It should be 5. So we filed a review petition.
You file review also?
Yes,
Okay, before the tribunal.
before the tribunal.
Okay.
And the second ground was to review and reduce the daily income of the deceased as it was in the higher side, that is 15,000,
Okay.
without any documentary evidence. And then the third one was the deduction should be 1/3 and not 1/4. As there were only few dependent, two dependent was there, but the tribunal has calculated, has deducted 1/3, 1/4 only instead of 1/3. And then the fourth ground was the interest rate should be slashed to the present bank rate.
Age of deceased was shown as per the judgment. How much what is the age shown by the judge in the judgment?
Actually, in the claim petition, it was 63. The
Hmm.
file mentioned as 63,
Hmm.
but as per the medical record and then the ID card, it was 70.
As per record.
As per the record.
No, in the judgment, how much age, what is the age shown by the learned tribunal? Age shown by the learned tribunal. His claim was that he was 63.
63.
But then in the judgment after evidence,
After evidence. $63.
after evidence, the,
After,
after evidence
after evidence.
in the judgment, it is shown 63 only. You are challenging on the quantum only? Quantum,
Yes,
okay. A is because it is higher in the higher side.
higher side.
Okay, so age is shown as 63 or
63.
63.
Yes,
Then you were given an opportunity to cross-examine.
yes, but in the review petition, they've slash it to
No, review also rejected.
no, one ground was considered
What ground was
regarding that,
considered?
regarding that multiplier. It was reduced to
Multiplier?
5.
Okay, it has been brought down to 5.
Yes, 5.
Okay, then no more grievance on that.
And then
Okay, now the
nothing.
only grievance is
Regarding
age.
the, no, age,
Sorry,
it's,
age done.
age is done.
Okay.
So regarding the income of the deceased,
Income, according to the judgment, it is 15,000.
yes.
So
And then
according to
the,
you, how much it should be?
it's on the higher side
It's
because
on the
no
higher side.
documents was provided, nothing was provided. And the court has come into the conclusion that her income was 15,000.
What he was doing?
Shop. She
Business?
was running, yes,
Business,
business.
naturally. Business will earn 15,000
And then the second was, one is deduction,
deduction in.
1/4, we've deducted 1/4 instead of 1/3. So
It should be 1/4,
it should be 1/3,
1/3.
yes,
Why?
but I'll place the authority before your lordship,
Okay,
because there are only two dependent
only two defendants.
of the deceased.
So as per the records, only shown that there is only two dependent.
Yes, your lordship. And then the interest rate, it was 9%.
Just a minute, huh? So with regards to the multiplier, you have no more grievance. That is
Yes,
done.
yes,
Okay,
it's all,
then age 63, age also done.
yes,
Okay.
H
Now-
and then multiplier, it's done.
Hmm?
It's in one round. H, as per the age, multiplier was there.
Multiplier,
So,
it was reduced to,
yes,
the
by the
from 7
order,
to, it was reduced to 5
one.
already.
Yes.
No more grievance
No
of
more
that.
grievances.
Now, the only grievance is income.
Income and then deduction,
Just a minute. Income, as per judgment, it is shown as 15,000
15,000
per month.
per month.
Now you, according to you, it should be,
It should be on because there was no evidence, no documentary evidence was there.
according to you, it should be how much, huh? It should be, according to you. It should be, huh? 20. Then you have to spell out,
5,000.
isn't it? You have to spell out, according to you, how much it should be.
It should be 5,000
Why?
because they even produce any documentary evidence regarding the business because there should be some licenses regarding the shop, but nothing was provided.
But then,
So as per the minimum wage egg, the interest, the income should be
so this
calculated
5,000 is based on what?
as per the minimum wage egg,
Minimum wage is 5,000.
5,000 or 4,800, something like that. So
It should be, no, minimum should be more than, it is 5,000 per month. No, minimum is the labor, the contingent, they get 11,000, I think, 11,000 contingent worker. That is the minimum. 11,000, isn't it? Is it so?
My lord, I'm not sure about that.
Not
There's
sure.
one judgment, but
Then
I
minimum
would
should be
like less.
15 also.
Yeah.
Because you,
Your worship,
Hmm.
the learned tribunal has discussed the evidence.
Okay,
The deceased was earning rupees 600 per day. It is reasonable amount.
600
It's
per
a
day
shop.
will,
She has opened a
then
shop.
it means it will
So,
go around 18,000 plus.
18,000, yes, so now.
But then it has been reduced to
Yes,
15,000.
15,000, yes.
If he was doing a business, probably 15,000 is reasonable.
Yes,
But then, if he was not doing anything, then of course it will go to minimum
Yes,
one, that is
yes.
11,000, if it is 11,000. But Nagaland, I have no idea, Nagaland, but then in other states, the minimum, the wage, the contingent
yes,
worker, the minimum, they used to get 11,000
per month.
per month.
But
So here I have no idea.
Yes, it is here, here it is normally on daily basis.
Daily
that I
basis.
paid, yes.
Then in daily basis, if it is
Yes.
say around 5,000 also, sorry, 500 also, the labor also used to get, I think,
Yes.
500, 400, 500
No,
something.
even above 600 normally
Above
nowadays
600. So
because of
even if
the
we
cost of
calculate for
living,
that
yes.
also, the wage earner, also, even if we take 500 also, it will be 15,000 only.
Yes,
So if it is 6,000, then it will go to 18,000, and probably 15,000, I think. So according to you, they could not show anything, and then since
Yes.
you are not also not showing, it's all the same.
yes.
My lord.
So, okay, so that is, then, and what is the next?
The next one is that the learned MSCT ought have deducted 1/3 from the annual
1/3.
income instead of 1/4.
Okay.
Because we were only
the
dependent.
dependent, only, how many dependent?
Two dependent.
Only 2.
Yes.
So then should have deducted 1/3. And according to you,
Yes, your
1/3.
lordship.
This I think is reasonable. Because dependent, if you could show only 2 dependent.
Yes,
Then-
the learned tribunal, considering the hardship goes to
No,
the
then
minor, one minor is
Ah.
almost having health problems, the minor. So because of that, taking that into consideration, the learned tribunal has made it 1/4, but as per the
As per the rule,
judgment,
it
it
will
is,
go.
as
It will
per
be,
the statute.
she has a
yes,
case here. Okay,
yes,
1/4.
it should be 1/3, it should be.
It should be 1/3.
1/3.
So 1/3,
Yes.
okay, then what next?
The interest rate.
Interest.
Yes, your lordship.
Hmm.
It's 9% per annum.
9%?
9%.
Yes.
The tribunal has given
Yes.
9%.
Yes, your lordship.
I think it's reasonable.
Yes. that
So
is
as
the-
per Sarla Varma versus Delhi Transport,
Hmm.
it's mentioned 6%. I want to place the authority before your lordship.
But
Lordship,
what is the
yes.
bank interest?
Bank and trace.
Bank, probably 9.5 or something, 9.
Yes,
What is the bank interest as of now? Sarla Burma, when it was passed,
It was passed in 2009.
and today is,
This is 24.
naturally there will be some difference. And then probably thereafter also some orders.
yes, so many judgments have been passed by
Judgment
this honorable
thereafter
court
also.
upholding the 9%.
You have a power to showing after Sarla Burma given
Your
more than
lordship, I
6%.
can-
Otherwise,
Yes.
she has advantage.
Several judgments have been passed, but lordship, I'll supply it to your lordship, some decisions that have been rendered earlier by this honorable court with regard to the where this court
It
has.
should be, as per Sarla Burma, it should be 6%.
6%, your lordship. Two 2009 6 ACC, page 121. The relevant portion is 142.
So, What is your submission regarding this interest?
Your lordship, with regard to the interest, this court has consistently been holding that 9% is 9% interest is.
This paragraph, you
Paragraph
have a printed
51.
copy. You have a printed copy. So printed copy.
Okay, I'll,
Para.
Para 51.
Okay.
We,
Para
okay.
51.
And then regarding the 1/3,
So this, supposing if land council for the respondent failed to show the power or any authority
Yes.
showing more than 6%, you'll get it. Huh? So
I'll supply
so-
your lordship with
okay.
the necessary.
So these 6% remain. If you could.
Yes, I'll do it within.
Okay. Yes. So and what else?
and then regarding the deduction of 1/3, it's in the same case, page 125. Page 125.
Where? Same. This is
Of the-
deduction.
125 page.
Paragraph
Itu
38 should be
dinas.
your lord.
Tadi dinasi mo. Judgment do. Itu TV do. Only the additions.
125 page.
Page 125.
Is para.
Para, second para. I may be allowed to read your lordship.
No, deduction, you succeed.
Yes, yes.
You succeed.
There is no.
In any case, you succeed in deduction because deduction as per the Sarla, it should be 1/3 only, not 1/4. So interest, if the land council for the respondent is able to show, you can show, then it will remain. Otherwise, it will go down to 6%.
Yes, your lordship.
Okay.
I'll
So we'll
supply
go
your
by,
lordship
we'll
with-
go by the
Yes.
the latest. Okay.
Yes.
And what else?
That's all.
all. Nah. So the other thing goes, okay, so we'll pass order. So in the meantime, you just
Yes,
submit.
I'll submit
Okay, when can you submit?
within 2 days.
In 2 days.
2 days.
Let us see then if you
Yes, yes.
submit, then you will keep it
Yes, your lordship.
the judgment reserve.
Yes.
Okay.
I'll.
This printed copy. Printed copy. Of this.
Yes.
You are Miss Ayla Incham.
Mua chung la.
What?
Mua chung la.
Okay. Land council for the applicant. And Mr. Tompo Pawner, land council for. Oh, sorry.
Respondents 1 and 2.
Yes.
Defendant. Yeah.
Mm,
Respondents 1 and 2.
Appearing on behalf of the respondent number 1 and 2 stuff. Hearing concluded, judgment reserved. Okay.
Obligation.
All right.
So give it. This. But that's not. I think we are on time.
Yes.
We have a meeting today.
Lordship, Lordship, I hope your Lordship has marked that item number 12 for that hearing for the Lordship.
Yes. Item,
Item 12, today's item 12.
yes, that is for hearing only.
Here. Okay, okay.
But, by the way, why it was listed on in order?
Orders today, because this honorable
Because of
court-
the
Yes, yes,
notice,
that,
because of
pro forma,
notice.
pro forma.
Okay.
Service has to be taken on pro forma.
Item 12, we have taken, huh? So that will be for hearing, huh?